Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com, and this is another episode of Ask the Lawyers. This time, we're going to touch on wills and trusts and who's in charge of making sure the trust is taken care of properly. And my guest knows all about this. He's attorney Charles Triay from the Triay Law Office in Oakland, California. Charles has specialized in probate litigation in the state of California for more than 30 years. Charles, thank you so much for your time today. I appreciate it.
Oh, you're welcome. Thank you.
Let's start off with just some of the basics. What is a fiduciary? And when we're talking about trust, what is that?
So a fiduciary is someone who is in charge of handling the estate or trust. Their title can vary. They can be called an administrator. They can be called an executor. They can be called a trustee. There's other titles as well, but basically no matter what the title, their job is to handle all the assets, pay the bills, and make sure everything's done properly.
And who picks the fiduciary? The person who set up the trust originally?
Yeah, that's the normal way. They specify which family member or which trusted advisor they wish to have as the fiduciary. But sometimes they don't specify, or the person they picked has died before them, and in that case, the court will pick somebody.
And so today specifically, we're talking about fiduciary accounting. What is that, and when does that have to happen?
Right. So no matter what type of fiduciary is handling the estate or trust, they are required to do an accounting unless the parties waive it. And in some cases, the parties will say, that's okay, you don't have to do an accounting. But 95% of the time, people want an accounting. And that is actually fairly detailed. They have to report on all the assets that they collect, all the income that comes in, all the bills that are paid, all the fees that are paid, and all taxes and everything. And it's quite a detailed accounting. It's not just a summary. And well, we can get into more detail on that, but they're required to do that at least once a year, generally.
That was my next question. Now, I would assume not all fiduciaries, or maybe they are, have a lot of accounting experience. Is this something they then can hire someone else to take care of?
Right. That's true. Many times you get somebody who's a family member who's never done this before, and they don't realize they have to do an accounting, or they're not the best record keepers. So when I have my clients in that situation, we hire a company that specializes in doing accountings. And that can be anywhere from a bookkeeper, your CPA, or whoever, or even a family member who has experience in that area. But the accounting format required by the court is very specific. And so a lot of people that have general accounting experience are still not familiar with that specific format that the court requires. So we do usually use a service that knows how to do it right so that the court will accept it.
And so you say the court will accept it. So once the accounting is done, does it have to be presented to the court?
That varies. In an estate, yes. In a trust, no. You can present it first to the beneficiaries, and if everyone's okay with it and signs off and says, I accept it, I don't have any questions or objections, then that trust accounting doesn't have to go to court. But there's sort of a wrinkle on that, is that what we find a lot of the time is that we have to go to court to force the fiduciary to do an accounting. So in that circumstance, I'm not representing the fiduciary, I'm representing a beneficiary, and the fiduciary, for whatever reason, isn't doing an accounting. So we will then go to the court and say, Your Honor, please make them do the accounting that's required. And then in that circumstance, they do have to file it with the court.
It would seem to me it would make sense that the accounting at least would need to be done initially, once the person passes it, because otherwise you don't really know exactly what you're working with, correct?
That's correct. And what you start with is the inventory, and that's a snapshot of what was present on the date of death of the parent. Bank accounts, value of the house, cars, collectibles, whatever, stocks and bonds, whatever. And then you have to do an accounting later to show how things progressed. In other words, income that comes in and expenses that go out, fees that are paid, taxes that are paid. The probate code says you have to do an accounting once a year. The court will normally not make you do that first accounting for about 6 months, because they know that this process takes a while. So they will want an inventory, a snapshot of what was there at the start, and then they'll give you some time to progress before they make you do the accounting.
You mentioned a minute ago that once they present it, if everybody says, okay, we're good with this, then you can move on. What happens if somebody is not good with it? If somebody feels like there's something wrong with the accounting, what's the process there?
Okay, so let me kind of come into that from a little different angle.
Okay.
When I'm representing a fiduciary, my job is to get that person off the hook and protected so that they can't be sued later. There's three ways to do that. One is to present an accounting and get everyone to accept it and sign off and sign the appropriate waivers.
Right.
Another way is to present the accounting and then wait 3 years for the time limit, the statute of limitations to run out. Nobody really wants to do that. That's too long. The third way is to present it to court and get the court to sign off on it. So let's eliminate that 3-year one because that's just too long. So yes, we present it to the beneficiaries. If everyone signs off on it, great. If not, either they go to court and say, we have a problem with it, or we go to court and say, Your Honor, please approve this accounting. The beneficiaries then have a chance to file their written objections saying what it is that they have questions about or object to. And then you're in a lawsuit, basically. And you can do subpoenas and written questions and live depositions. And then eventually you either settle the case or you go to trial and the court decides. Let me comment one thing there. What a lot of people don't realize is that at least 95% of all cases do not go to trial. So I'm not talking about the ones that were signed off on without even going to court. I'm talking about the ones that get filed in court. 95% of those do not go to trial.
Oh, okay.
They end up with a negotiated compromise settlement. And the reasons for that is the court process takes forever, it costs a fortune, and nobody knows how it's going to turn out. And especially on these accounting disputes, it's very rare for one side to get a 100% win. So generally speaking, we'll go through the process, but we'll end up with a negotiated settlement.
So even if there is a negotiated settlement, even if it doesn't go to trial, there can still be court costs and attorney's fees involved. How does that work? Can the fiduciary get those costs back from the trustee and vice versa?
Yeah, that's a very good question. I'll try to give you a short answer. The starting point is that the trustee fiduciary can use the trust assets to pay their attorney to defend themselves and defend their accounting. The beneficiaries cannot. The beneficiaries either have to pay their attorney out of their own pocket or run a tab. Say, I know I'm good for it. I know I'm going to be getting a trust share of so much, and I'll pay you, Mr. Attorney, when I get that money. The probate code, however, allows for the court to shift those fees. If the court determines that, for example, the trustee acted in bad faith, lived in the house rent-free and didn't compensate the trust for that, paid his own bills, stole money, whatever, and then used trust money to defend himself from attack solely to protect against personal liability, the court can say, no, that's not right. You, Mr. Trustee, have to reimburse the trust for those attorney's fees that you used to defend yourself. And the court can go further and make the guilty trustee pay the attorney's fees of the beneficiary. And that goes both ways. If the court determines that the beneficiary's complaints were in bad faith and not supported, the court can make the beneficiary pay the trust the attorney's fees that were incurred by the trustee. Now, I have to say that this fee shifting, while it's in the code, is very rarely done. The court usually says, all right, you were wrong, but I understand why you felt that way, so we're not going to shift the fees. But this illustrates a problem with these trust accountings and another reason why they all settle. Let's say we're talking about a dispute of $50,000. We think the trustee spent $50,000 or owes $50,000. The beneficiary is going to spend a lot of money on attorney's fees. The trustee is going to spend a lot of money on attorney's fees. And you end up having to make a financial decision. Is it really worth it to spend $20,000 chasing $50,000,
Right.
especially because I'm not 100% beneficiary. I'm only going to get a fraction of that as my share. So there's a lot of balancing and math that gets involved in trying to figure out when and whether to settle these cases.
If you, in conclusion, Charles, if there's one thing you wanted people to know about when it comes about fiduciaries, trustees, trusts, and all that, what would be one thing you'd want everybody to know about all this?
I guess I would say two things. The first one is being a fiduciary is a thankless job. And while it pays, it doesn't pay well. And most people would be well served to get a professional trustee from the beginning.
Okay.
The second thing is if you have an accounting dispute, get help right away. Get an attorney, get an accountant, do it right, because people fumble around and they waste a lot of time and a lot of money before they get things on the right track.
So, and I would guess it's important to get somebody who has a lot of experience like yourself, many years of experience in just this area, correct?
Oh, absolutely. I see a lot of attorneys who think that probate is easy, and they come in and they find out that it's a very unique area with lots of different rules, lots of time limits, and they have a hard time. Right. So get an experienced probate attorney.
Awesome. Well, thank you again for your time, Charles. I appreciate it. I think you've answered a lot of questions for people today.
Thank you.
My guest has been Charles Triay, an attorney in Oakland, California, and that'll do it for another episode of Ask the Lawyers. Please take a second and click on the box down at the bottom of the screen to subscribe to our YouTube channel so you don't miss any future episodes of Ask the Lawyers. If you want more information and you're ready to contact a lawyer, make sure to go to askthelawyer.com so you can choose a lawyer that lawyers choose. I'm Rob Rosenthal for AskTheLawyers.com.